Welcome to today's episode, where we tackle the concept of judicial lawfare and its impact on American governance. To start us off, could you explain what judicial lawfare means and why it's becoming such a hot topic recently?
Absolutely. Judicial lawfare refers to the strategic use of courts and legal processes to advance political goals, often by blocking or dictating executive actions. Unlike traditional adjudication, this approach leverages legal rulings as tools for partisan or policy ends, raising concerns about judicial overreach.
That sets the stage well. What has changed in recent years to make this phenomenon so pronounced, especially regarding executive powers?
Historically, courts acted with restraint, especially in nationwide policy issues. In the last decade, however, we've seen a surge of federal judges issuing broad injunctions that halt executive actions nationwide, not just in individual cases. This shift has ignited debate over separation of powers.
Let's dig into district judges specifically. Can you clarify how their role fits within the federal government and how their recent actions differ from traditional expectations?
District judges are trial court judges, meant to interpret and apply law in specific cases. Traditionally, their rulings impacted only the parties before them. Lately, however, some have issued nationwide injunctions, effectively setting policy for all 330 million Americans, which was rare in the past.
So one judge in, say, San Francisco or Baltimore can now halt an executive order for the entire country?
Exactly. This power, while legally justifiable in some circumstances, raises concerns about a single unelected official potentially overruling the elected branches and dictating national policy.
Let's transition to the topic of nationwide injunctions. When did courts begin issuing these, and why are they so controversial today?
Nationwide injunctions were virtually unknown in the first 150 years of the Republic. The first significant surge came in the late 20th and early 21st centuries, often in response to controversial executive orders. Critics argue they allow a single judge to block federal policy everywhere, not just locally.
Are there any statistics to illustrate how dramatic this change has been?
Absolutely. For example, there were 0 nationwide injunctions in the first 150 years, 27 in the entire 20th century, but over 60 during President Trump's first term alone, and already over 40 in just 4 months since his return to office.
Those numbers are striking. How do these developments threaten the principle of separation of powers that underpins our constitutional system?
Separation of powers is designed to prevent any one branch from dominating. When courts issue sweeping orders that block executive or legislative actions nationwide, it can upset that balance, turning judges into de facto policymakers rather than neutral arbiters.
Could you offer an analogy for listeners who might find these legal concepts abstract?
Imagine a sports referee suddenly rewriting the rules of the game mid-match. Instead of enforcing existing rules, the referee starts dictating how teams play, overshadowing both coaches and players. That's the sort of imbalance critics fear.
Let's illustrate this with concrete examples. Recently, a New York City court struck down President Trump's tariffs. Walk us through what happened and why it matters.
Certainly, the Court of International Trade ruled that the tariffs imposed exceeded presidential authority under the AIPA, effectively nullifying a central piece of economic policy. Critics argue that instead of reviewing legality, the court replaced executive judgment with its own policy preferences.
And what was the outcome after this ruling?
The decision was quickly stayed by the Court of Appeals, highlighting a tug-of-war between judicial layers. Still, the initial injunction demonstrated how a single court's interpretation can disrupt national economic strategy almost instantly.
Moving to immigration, another high-profile case involved a Maryland district judge blocking deportations. How did that decision reshape national policy?
The judge issued an order providing automatic protection to anyone detained as an illegal immigrant who filed a habeas petition in Maryland, regardless of where they were detained. This effectively paused deportations nationwide, overriding executive enforcement priorities.
Were there any attempts to reverse or limit the scope of that order?
Yes, the judge amended the order in response to criticism, but the initial impact showcases how a single judicial action can upend federal immigration enforcement overnight.
Election law has also been a flashpoint. Recently, a D.C. judge blocked requirements for proof of citizenship to vote. Could you explain the significance of this ruling?
Of course, the judge's injunction overturned election integrity laws across all 50 states, arguing that the requirement was unconstitutional. This ruling extended far beyond the original parties, setting national standards from the bench and sparking heated debate over voter security and judicial reach.
What are the broader implications of a single court making such sweeping decisions?
It centralizes immense power in the judiciary, potentially sidelining state legislatures and Congress in matters traditionally under their purview.
Shifting gears, let's talk about social policy and energy. How have judges recently influenced these areas through nationwide orders?
In Boston, judges have ruled on birthright citizenship and energy rate caps, while in Rhode Island, courts have compelled federal disbursement of millions in public funds. Such decisions affect everything from taxpayer costs to social program eligibility, often based on cases with just a handful of plaintiffs.
That seems like a departure from case-by-case adjudication. What are critics most concerned about here?
They worry judges are venturing into policymaking, stepping beyond their constitutional role and substituting judicial preferences for legislative deliberation.
Let's explore the patterns. The data shows most universal injunctions come from just a few districts. Are there political or structural reasons for this concentration?
Indeed, litigants often file cases in jurisdictions perceived as sympathetic to their causa practice, called forum shopping. Also, recent administrations, including President Biden's, have appointed judges with strong policy views, sometimes intensifying the trend towards judicial activism.
So judicial appointments can have far-reaching consequences beyond individual rulings?
Exactly. The ideological leanings of judges can shape national policy through their willingness to grant or deny broad injunctions, potentially for decades.
As we wrap up, let's discuss solutions. What reforms are being proposed to address these concerns and restore balance among the branches?
Some advocate for limiting the geographic scope of injunctions, requiring appellate review before nationwide orders take effect, or even revisiting the process for appointing district judges. Others propose greater transparency and accountability to ensure judicial decisions reflect legal, not political, reasoning.
Do you think these reforms could truly safeguard democratic norms and separation of powers?
They're a start. Ultimately, maintaining the delicate balance among the branches requires ongoing vigilance, respect for constitutional limits, and informed public debate, exactly the conversations we're having today.